Okay, Mr. and Miss Roberts, are you there? Can you hear me?
Yes, we
Yes,
both can.
Okay, very good. So we'll go on the record in Roberts versus Roberts. This is file number 2520276. The record should reflect that both parties are present today by Zoom video. I have this set for entry of a final judgment of divorce. Mr. Roberts, is that how you wanted to proceed today?
Correct.
And
Yes,
Miss
Your Honor.
Roberts? Okay.
yeah,
And Miss Roberts, is that how you wanted to proceed as well?
yes, yes, sir.
Your Honor.
Yes, Your Honor.
Okay, can you both raise your right hands, please? Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your
Yes,
Honor.
yes, Your Honor.
Thank you. You can lower your hand. I'm going to be asking you both a series of questions. The questions that I'm going to be asking you are those that I'm required to ask in order to establish the grounds for divorce under Michigan law. Mr. Roberts, since you're the one that filed for divorce in this case, I'm going to start my questions with you. You filed a complaint for divorce in this case and you signed that complaint. Is that true?
Correct. Yes, Your Honor.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, Your Honor.
Had you been a resident of Otsego County for at least 10 days?
Yes, Your Honor.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes, Your Honor.
Does that remain true today?
Yes, Your Honor.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, Your Honor.
All right. And under this divorce, you are not going to be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, Your Honor.
And then you and Miss Roberts have already divided up all your personal property, your belongings and assets and debts of the marriage. Is that correct?
Yes, Your Honor.
All right, and then there's a piece of real property here in Vanderbilt. And under this judgment, it looks like both of you are going to remain 50% owners of that property. Is that correct?
Yes, Your Honor.
Is there any debt associated with that property, a mortgage or anything like that?
No, Your Honor.
Okay. All right, and then you're each going to pay half of the taxes. Is that correct?
Yes, Your Honor.
Okay. And then you're both going to have the right to remain on that property according to the terms in this judgment. Is that right?
Yes, Your Honor.
Okay. All right. Ms. Roberts, have you heard all the questions that I asked Mr. Roberts?
Yes, I have, Your Honor.
Have you heard all of his answers?
Yes, I do, Your Honor.
Do you have any reason to believe that any of the answers that he gave were untrue?
No, Your Honor.
Are you currently pregnant?
No, Your Honor.
Okay.
No.
That's one of those questions I am required to ask that under law. So I'm not
Passing
trying to be not trying to invade your personal life there. You also are not going to be receiving any alimony or spousal support. You understand that you also would be waiving that forever and would not be able to come back later and ask the court for that.
Yes, Your Honor, I understand that.
All right. And then do you agree with regard to the real property, how you guys are going to handle that going forward?
Yes, yes, I do, Your Honor.
Okay. So are you both currently on the deed to that property?
Yes. Yes, we
All
are.
right. So one of the things, because I think the two of you may want to consult a lawyer because you may need to change that deed to reflect what's here in this judgment of divorce. Because whatever the deed says now, I mean, that's what's recorded. The judgment of divorce gives you the authority to change the deed, but it doesn't change the deed, on its own automatically. You would need to draft a new deed and file that with the Register of Deeds and record it. So that's something that I think the two of you may want to follow up on. And if you think you need legal help with that, maybe to consult a lawyer. Otherwise, your interest is going to remain the same as it is now until you draft up a new deed and have that recorded. Do you understand that?
We understand.
Okay. All right. Other than that, let's see. Miss Roberts, are you asking to have your name changed or no?
No, no, Your Honor.
Okay. Okay. All right. Do either of you have any? The court finds that the statutory grounds for divorce have been met by the testimony of the parties. The court will grant the divorce and I'll sign that judgment. So that means your divorce is final as of today. Do either of you have any questions about that?
No, Your
No,
Honor.
Your Honor.
Okay. All right. Thank you. That's all for today. And you're both free to disconnect at this time.
Okay, thank you.
Thank you.
Thank you. Ms. Jackson, are you there?
Yes. Yes, I am. Can you hear me?
Yes, I can hear you. I can't see you.
Let me see if I can fix this. Hold on. Whoops, I'm not sure.
And Mr. Jackson, I just need you to unmute, please.
Can you hear me?
I can, yep. And Ms. Jackson, you're fine. I can hear you good, so that's what's
Okay.
important.
All right. Sorry about that.
It's okay. So we'll go on the record in Jackson versus Jackson. This is file number 1917704. The record should reflect both parties are present today by Zoom video. Ms. Jackson, you filed this motion to enforce the judgment. You're asking the court to order Mr. Jackson to quit claim that property in Elmira pursuant to the terms of the judgment. Is that correct?
Yes, sir. That's correct.
Okay. Is that still an issue that still hasn't been done as of now?
That's correct.
Okay. Mr. Jackson, is there a reason why you aren't signing off on that property?
We got our divorce 6 years ago, and it was a fake divorce for my granddaughter, and I lived there up to last year of that residence.
Can you say the first part about your granddaughter? I didn't catch that.
I moved out because my ex-wife was trying to get custody of my granddaughter, and I had a previous charge. But I never moved out. I just went to court and I signed the house to her. That way it looked good for paper.
Okay. Is there a reason why you haven't signed off on it yet up until now, though?
It was a fake divorce. We were still together. We never separated until just recently.
Okay. Well, I mean, from a legal standpoint, it's not a fake divorce. I signed a judgment that legally divorced the two of you, and in that judgment, you're required to sign off. So even if you've been living together, let's say up until last week, is there a reason why you're not signing off on it now?
I guess I don't know what she hasn't done her part. She was supposed to do something, and I had to do a quick claim. And she had to start the process. Is the way I understood it.
Okay, so you're saying she's never presented you with a quitclaim deed to sign?
No.
Okay.
She's just doing this now because I got remarried. She's kind of upset because I moved on. But no, I got no paperwork from her whatsoever to just recently. I got a week and a half ago, this court date.
Okay. All right. So Miss Jackson, I mean, I guess what you need to do is have a quitclaim deed prepared. Mr. Jackson, if she presents it to you, will you sign it?
Can I get my stuff? If you won't give me my stuff.
Your Honor, may I interrupt?
Hold on. Everybody's talking at the same time here, so you can only have one person talking at once. So Mr. Jackson, I mean, I don't know what's going on in terms of disputes you may have regarding your property, but that's a separate issue. And if you feel that she's not returning something that you're entitled to, then you would need to file your own motion. And I would certainly consider that in due course, but right now I'm not hearing any reason why you shouldn't sign a quitclaim deed if it's presented to you. So, Ms. Jackson.
Because he tricked me, Your Honor. If I knew that, I wouldn't have gave my house that I paid free and clear for, a paid house. I would not just give it away. I would have fought for it.
Well, here's the thing, Mr. Jackson. I mean, you've come up with now 3 different reasons why you don't think you should have to sign this. And this isn't a moving target. The divorce judgment says that you need to sign a quitclaim deed. So there's no reason right now why you shouldn't be required to sign that. If you feel that somehow you've been wronged under this judgment, then like I said, you need to file your own motion, but none of that is a reason why you can refuse to follow a court order, which the judgment is. So, Ms. Jackson, again, if you prepare a quitclaim deed and you present that to Mr. Jackson, can you do that within the next 30 days?
I can do that by Friday.
Okay, so All right, so Mr. Jackson, you're gonna have 30 days from the date that she gives you that deed to sign it and return it to her. If you fail to do that, then you may be subject to contempt sanctions, which can include fines and even up to incarceration. I don't want to do any of those things because it's pretty clear that you need to sign off on this property under the judgment of divorce. If you feel that you have some legal argument or she hasn't followed what she's supposed to do, then like I said, file your motion. I'd be happy to consider that as well. Okay.
Okay.
Do you have any questions about that?
No, Your Honor.
All right, so Miss Jackson, his clock doesn't start running until you get him that deed to sign. Do you understand that?
Yes, Your Honor.
Okay. All right, so I will do a written order that reflects what we discussed here today. You both will get a copy of that, and then we'll go forward from there. Miss Jackson, do you have any questions?
I just, I also asked for the court to grant me my maiden last name.
Yep, so that's something, if you wanted the court to do that, that would have had to been done at the time the divorce judgment was entered. So I
Okay.
can't do that now. You need to get a separate petition and file that with the clerk's office to change your name.
Thank you so much, Your Honor.
Okay, Mr. Jackson, do you have any questions?
No, sir.
Okay, all right, thank you. That's all for today. Both parties are free to disconnect at this time.
Thank you.
All right, we'll go on the record in Degraz versus Dash. This is file number 2419634. This was set today for a hearing on plaintiff's objection to a referee's recommended order from back in December. The hearing was set for 9:30. It's now 9:35. Neither party has appeared today. The court will reset this for another hearing in 30 days. If neither side appears at that hearing, the court will dismiss the objection.